Hey everyone, welcome to tonight's meeting of the Planning and Development. We're not expecting any fire tests or alarms, so if you hear the alarm, it's likely to be a real event. If that occurs, please leave the building by the nearest safest exit, which is likely to be that door, and go to assembly point G on the car park, which is straight outside those windows. Please don't simply leave the building because we have a register of everyone who's here, which we're required to give to the fire brigade. If for any reason we can't use that door, it'll probably be the Civic Suite door that you came into the building by. Agenda item number 2 is apologies for absence or members away on official council business. I have apologies from Councillor Phillips, who's replaced by Councillor Turley. Councillor Gosling, who's replaced by Councillor Barnett, and Councillor Reary, who's replaced by Councillor Waffles. Members, are you all content to note those changes? And also be welcome to the meeting. I hope you enjoy it. Agenda item 3 is disclosable pecuniary or non-pecuniary interest.
Chair, 7D, non-pecuniary. I know the language really well. Thank you. Do you want me to leave the room or sit and not take part in?
I think stay and not take part is fine for that.
Okay, thank you.
Councillor Fowler?
Chairman, due to the proximity of my home house, 7F, I've been advised to declare the interest here, and likewise, should I stay for this techniques?
I again, unless advised to the contrary, I would simply sit through the meeting and don't vote or say anything.
Okay, thank you.
Members, I just have one other item I wish to draw to your attention before we go into the meeting. Yesterday, Councillor Riley was 708 months old. I'm surprised he could still walk into the building.
Thank you, Chair.
I'll leave the rest of you to work out exactly how many years. Agenda item number 4 is the minutes of the board held on the 7th of September. Are you all happy that I signed them as a correct record?
Great.
Thank you very much. Agenda item number 5 is the Nuneaton and Bedworth Borough Local Plan Regulation 19 consultation. Mr. Brown, anything to add to your report? Oh, Mr. Dittman, anything to add to your report?
Thank you, Chair. I'll try and be brief. Just to establish the settings of the current Regulation 19, this is one of the formal stages of the Nuneaton and Bedworth Borough Plan. Members may recall previously in 2022, I think it was July, we had a similar response to the scope, issues and options report. That is the set of responses you see in Appendix A. In terms of this next formal stage, we still maintain our objections, particularly with regard to the 3 main issues: duty to cooperate, housing and employment. On duty to cooperate, we consider this not being adequately addressed in that the draft MOU, which is in Appendix C, doesn't best reflect the fact that the borough also lies within our borough, that is not the Nuneaton, lies within the Birmingham housing market area, as well as the Coventry housing market area. So we want that reflected. In housing, we are concerned that the new Reg 19 plan only appears to primarily address their local needs. The HEDNA, which all the sub-regional authorities within Coventry Warwickshire are looking to, in terms of their evidence base, seeks more housing above their own local needs, and there needs to be a clear sub-regional agreement in the housing split between boroughs of any additional need, and clarification and reassurance is sought from that approach will be taken. Again, that reflects on the duty to cooperate. Memorandum of something at the end in Appendix C, because we don't believe that adequately reflects it. On the third issue, employment, the Reg 19 plan does identify no strategic sites. We currently in our local plan have a general policy of addressing application that come forward on that basis. and that they do not provide details within the plan or in the MOU about how the contribution to the B8 logistic requirement that is identified also in the headnote will be addressed. And the recommendation, as you can see at the front, in terms of reserving that to the Chief Executive, is primarily to seek a member meeting between yourselves and Nuneaton and Bedworth to discuss this local plan, and that a revised statement of common ground is drafted after that meeting. The drafting, which is only current draft, in Appendix C, I don't believe addresses the issue, and it doesn't address the level of housing that we are providing. In the meantime, as this is a Regulation 19 formal stage, it's recommended that we maintain the objections as I highlighted in objection to the Bedworth for the local plan. This being reviewed following the member meeting to be arranged as recommended above, and then going to the executive for final review. Thank you.
Thank you much. Members, any comments? Councillor Biden, one Councillor Higgins.
Thank you, Chair. I'd like to thank the officers for their work as detailed in Appendix A, and I fully support the repeated observation that the plan is not sound.
Councillor Hayfield?
With all that, I'll move the recommendation.
I second that and repeat the comments that Councillor Riley has made. I think we should be very grateful for the amount of work and diligence of the officers in wading through what appears to be quite a matter of information. It's quite difficult to understand when you try to get through it.
Any other comments, members? I'd just like to draw everyone's attention, in case I'm sure you have seen it, but Nuneaton and Bedworth are seeking to justify more housing in their area than is justified by the local need. And, so that's a difficult premise to start from. And then they're justified on the grounds of the economic vitality of the borough, but that must have significant implications on their neighbours. I think there's an awful lot in it. I absolutely agree. It's important to emphasise that their draft plan is not sound. I do have, as well, significant misgivings over the proposed memorandum of understanding, particularly given the demise of its predecessor. But I emphasise that I am keen that we carry on a dialogue and we seek to understand how we can cooperate with our neighbour as much as anything to ensure the protection of sites within our borough and the people that we represent. It's important that we understand what their issues are and how we could seek to overcome any potential risks to our borough by working in an understanding and cooperative way. If no one has any more comments, it's been proposed and seconded that we object to the plan and that the final response be delegated to the Chief Executive. See those in favour? That's unanimous. Thank you very much. Agenda item number 6 is the submission of the Nether Whittaker Neighbourhood Plan for referendum.
Thank you, Chair. This is a straightforward recommendation that the Nether Whittaker plan be taken to referendum, forward for referendum. The plan has been examined by ourselves and meets the basic criteria. It accords with the current adopted local plan, and effectively recommend that members take it forward for a referendum. Thank you.
Thank you very much. Members, any comment? Councillor Riley?
Thank you, Chair. I'll leave the recommendation, there are lots of time and effort that goes into the production of these plans, and they are certainly valuable documents when they come to board and help us aid our decision making. I am conscious that this plan is now a mature plan and it's been through significant parts of the process. I read it with interest when I looked at the development boundary, and I read it with interest when I looked at the economic strategies, which I thought perhaps could be a little bit stronger and perhaps more inclusive of what we now know to be the significant risk that HS2 presents to Netherwick community through the 10 years of construction, which we still have to live through. However, Chair, I note the recommendation to the board and move the recommendation.
Thank you. Councillor Lively.
Thank you, Chair. I'd like to second the recommendation. It's no easy feat trying to put together a neighbourhood plan for your area. I have to say, you've got experience of this, but I thought it was a comprehensive list of things to help us sort of like Netherwick to keep going forward. And I've got a soft spot because my maternal grandfather was born there. So well done, David.
Councillor Evans.
Yeah, I'd like to thank the authors of it, because obviously there is a lot of work there, but it was written in a very clear way that was easy to understand and didn't rely on obfuscation to everybody into accepting it. It was very clear, very well written in my opinion.
Thank you. If no one else wishes to speak, it's been proposed and seconded. I see those in favour. That's unanimous as well. Thank you. We now move on to the planning applications themselves. The first one is a consultation for land off Caldicott Lane in Caldicott. Mr. Brown, anything to add to your report?
First of all, Mr. Chairman, I'll just run through the slides if I can get them on. Here we go.
I have to say, Mr. Brown, that was a personal best, wasn't it?
The next one doesn't move. Which doesn't help me at all.
Too soon, Chair.
Oh, he's got three hands. Have you noticed?
Next slide. So just get down the list.
Yeah.
Right, we'll get to the plans, Mr. Chairman. This is a consultation by the County Council. The County Council has received this application for the pumping station south of Caldicott, and we're asked to comment on it. The location of the plan, as you can see, the site is there. Caldicott is here. Caldicott is up into the top right, with the 444 quite some way to the left. In terms of the site itself, you can see the landscaping around it, the access in, and then the pumping station as drawn there. They have provided a cross section showing some development above ground and some development below ground. As you'll see from the report, Mr. Chairman, we're not very comfortable with this for two or three reasons: noise, odour, and the impact on the forthcoming conservation area to be declared at Caldicott. And that's clear in the report. During the end of last week, Mr. Chairman, I received three reports from the applicant from Severn Trent on behalf of Severn Trent, one in respect of each of those issues. They've gone out to consultation. The noise and the odour one has gone to our environmental health officer, and the heritage one has gone to our conservation officer, and they have not responded in the time that they've had available. So, Mr. Chairman, I'm indicating to you tonight that we maintain the objection as outlined in the report, but we defer. The board may want to defer this item until they've had the advice of those officers, and we report back to you in November at the next meeting. And in light of the significance of those three items, I have been in contact with the applicant, and the applicant is willing to meet representatives of the board to run through some of the issues involved if the board would like to do so. Thank you, Mr. Chairman.
Thank you, Mr. Brown. Members? Councillor Derrick?
I think we should defer with representatives for further information.
Thank you, Chairman. I'm quite happy to propose deferment. I have actually seen the three reports, I do think some of them are inconclusive actually, and I think we do need to see them and see the responses from our officers on them. Also, I would like to know where we are with the conservation area at Caldicot, because one of the reports was fairly dismissive as the conservation area has not been adopted. I don't know what the correct term is. So I asked Mr. Brown in a minute. And also, they didn't seem to have looked for any alternative, less sensitive sites than this. This is a really sensitive area. So I'm quite happy to the deferment. But I would like a response from Mr. Brown, please, on the conservation issue. Thank you.
Thank you. Mr. Brown?
In respect to the second item, Mr. Chairman, I suspect this is an item or an agenda item for that meeting if members want to meet with the applicant to see what alternative sites they may have looked at. They'll have to go up and down the pipeline, Councillor Bell, so it'll have to be along the line, so to speak. In terms of the conservation area, that's correct. The conservation area has not yet been adopted, therefore doesn't carry full weight. However, like neighbourhood plans and local plans, because it's gone through consultation and we're moving now through consultation to adopt, it has some weight but not full weight.
And do you have a rough timetable, Mr. Brown, for when we might adopt the conservation?
We'll make sure, Mr. Chairman, that's in the next report to you, but I will email members after having spoken to the conservation officer when she returns from leave.
Thank you very much. Members, it's been proposed and seconded for deferment. Can see those in favour? And that's unanimous. Thank you very much. Agenda item number 7B is planning application number 191 for Willows, Tamworth Road, Kingsley. Mr. Alex Bruce has indicated he'd like to speak. Mr. Bruce, if you take the speaker's chair while Mr. Brown introduces his report.
Thank you, Mr. Chairman. Just the initial slide to start with. That's all we have on this one. You can see the site on the top of the slide there, outlined in red. The buildings at the top are Cliff, and the main road that goes to the centre of the plan is the Tamworth Road between Kingsbury and Doshill. The overbridge over the M42 is just to the south. The River Tame, as you can see, bends its way on the left-hand side there. And you can see the other properties to the south of the site. The plan at the bottom is the site layout. You can see the pitch, which is referred to on the board, located at the far west of the site, overlooking the River Tame embankment. And you can also see the line of the bunds there, which went their way across the site, and the proposed landscaping that's involved. The two properties which I'm referring to are at the bottom here. Which is referred to in the committee report, and the site of the previous proposals is on the front here, between the access drive and the building that you can see there on the site. I must repeat, Mr. Chairman, some of the comments that are in the report for the board. It's important to treat this as a fresh application on its own merits. I know there have been cases that have come to you before on this site, but this is a fresh application. In that respect, the proposals have changed, which means that the weights that a decision maker has to give to those particular considerations has also changed. The harms are different, in my view, both spatially and visually to the instances we've had before, and that's expressed or concluded in paragraph 420 of the report. And also the other considerations put forward by the applicant have changed. Particularly the progress on the Gypsy DPD, as used an options paper, and the potential for a 3-year consent, which the applicant is offering to you. That's outlined in paragraph 425, beg your pardon. So in our view, Mr. Chairman, this particular case now is far more finely balanced than it was in previous cases, and that's outlined in paragraph 4.28 of the report. And that leads us, Mr. Chairman, to a recommendation of approval for a temporary consent for 3 years. Thank you.
Thank you, Mr. Brown. Mr. Bruce, welcome to the Council House and to the meeting. Mr. Brown will explain the rules on public engagement to you now.
Mr. Clerk, good evening. In a moment, you'll be given 3 minutes in which to address the board. So I'll let you know when 3 minutes begins. If you still speak, I'll let you know when you've got a minute remaining, and then if you still speak at the end of 3 minutes, when the time is ended. On your microphone in front of you, you should have a button which press the microphone. Okay. Your 3 minutes stops now.
Thank you, Mr. Chairman. And thank you, Mr. Brown, for summing it up. So the key differences between some of the other cases which you've seen, or you maybe, would be the DPD. So ultimately, there was a recent inspector appeal which went through on the basis of the need, and substantive weight should be afforded to this, basically. In addition to this, this is why we put forward a temporary consent. So the temporary consent would be for 3 years, and that would enable to get us to a period of 2020 SIPs, etc. Basically, where we know where the DPD is at that point, and then at that point, the applicant would default the pitch back to agricultural land, etc. Or if the DPD is no further forward, then a removal variation would take place at that stage. So this is just a temporary consent for 3 years for the applicant to live on there. It's key that it's just, we don't contest that it's inappropriate development in the Greenbelt, but there are substantial planning balance merits which should be accounted for. You have extensive tree planting proposed. It adjoins the existing caravan site now, so it's now at the very back of the site. So when you're talking about the spatially and the visual aspects of the Greenbelt, it won't be seen. The pitch won't be seen. The character will be retained because it'll be right next to other caravans. And, you still have the overarching issue of the children as well, of the applicant, where he has 4 children, and they were seen to be doing very well when the applicant was at the site in 2018, and the head teacher did, apply to that. 1 minute, okay, that's fine. And so the inspector had actually said in the previous appeal in 2019 that the children were doing very well and moderate weight should be afforded to this. That weight should still apply, but it's the case that the weight has been shifted from the Greenbelt, etc., and there is now more weight than previous, and the temporary consent is a huge deal compared to it. And if the DPD is no further forward, then they go for a variation. If it's further forward, then hopefully they then have a pitch which they can move on to in the 3 years. Thank you.
Thank you, Mr. Briggs. Members, do you have any questions for our speaker? Councillor Wright.
Thank you. I'm interested to hear that you recognise there is a Greenbelt consideration on this site, and clearly we're all deadly conscious about very special circumstances. Now, you've told us that children are doing well at school. Are there any very special circumstances which you feel are appropriate?
So the key is that very special circumstances are weighed in the planning balance. So it's not the case that something has to be very special. It's the case that the cumulative impact is enough to outweigh the balance. So in this case, you do have the tree planting, the character being retained, the new bunding, which makes the site basically invisible. As you can see in the Greenbelt, there's many things which you can see which are visually worse than what this will be, and it's a temporary point. So basically, it's only for a temporary period of time, and it'll be reverted back to Greenfield. Ultimately, if the DPD does what it's supposed to and delivers the pitches which it needs to for my applicants, then it'll be returned. That's the overriding point, and that's what's in my head.
Members, any other questions? Thank Thank you, Mr. Bruce. Thank you very much. Members who'd like to begin the discussion? Councillor Parsons.
Thank you, Chair. Yeah, I'm aware of the considerable change, as it were, from the previous applications here. And I'm moved particularly by the arguments concerning the children. The granting of opportunities to children is fundamental to our society, in my view, and fundamental to the role we should take on as a council. It is one pitch. It is a temporary situation, and the fact that these children are and can be established in a local school, it is often a very difficult step in the travelling community, weighs me very much in favour of voting in support of this measure. Thank you, Chair.
Thank you. Councillor Hayfield.
I've read the report and I agree that it is in many ways finely balanced. I'm not sure that on its own, the interests of the children and their education count as a very special circumstance when it comes to Greenbelt. Maybe there's an argument that cumulatively you could put such a case forward. But Chairman, I'm not persuaded. I think Greenbelt overrides this, and I would move that permission is not granted.
Thank you. Councillor Riley.
Thank you, Chair. I think it's a challenging application, isn't it? The papers demonstrate how long this has been going on for, and as with all applications, consider that there is always a family or an individual that is impacted by any decision you make, whether it be positively or negatively. I support Councillor Hayfield's position, specifically around policies LP3, which is the Greenbelt, and the halves to the Greenbelt, policy LP10, which is the Gypsy and Traveller strategy, recognising that a DPD is now in development, and also policy LP14, which is around the landscape and the character of areas. At the moment, Chair, with the bund, with the additional pitches, I think that there are serious considerations about policy LP10 and landscape and character. And I certainly don't think that a case has been made out to address policy LP3 about significant harm. It is fabulous to hear that children are doing well. But in terms of Greenbelt impact, it is not evidence to outweigh significant harm to Greenbelt.
Thank you. Any other Councillor Bidden?
Thank you, Chair. I actually went on the site visit on this one because I am quite passionate about saving our green belt and our green spaces. And it is a tough one. I echo what everybody else has said, Councillor Parsons and Councillor Riley. But standing on the site, I do think it would be an appropriate development to the green belt, and the weight that is given to the special circumstances does not reach the level that I could support this application. So,
thank you. Any other comments? Councillor Dermot?
I would just like to add really that I would be happier the planning permission, should it be granted, was for a specific family with those children. At the moment it reads as if once the permission has been given, anybody can come along and occupy the site, which then goes against the what I perceive as the intentions of this application.
Thank you. Councillor Bates.
I think just like Councillor Ridley has mentioned, really, I also went to the site visit on this one, which is the first time as a new councillor that I went on site to have a look, and just echo what Councillor Ridley has mentioned, really, in regards to the Greenbelt land. We did a walk all the way down to the very bottom of the site, right through, and I too couldn't support it with the Greenbelt issue.
Thank you. Mr. Tobin, I'm conscious of the delicate balance which the board needs to way in reaching its conclusion. And personally, I've read the whole of the report. I understand the changed circumstances. I understand the different weight that the planning officer is attaching to the different elements of the application, which has led to, in his opinion, a changed recommendation. Is there anything within all of that and that you feel should be drawn to the board's attention specifically from a legal perspective before members weigh those questions and reach their decision?
Sure, it's a comprehensive report and it the circumstances of this application and the previous application and decision that was made. And of course, you have to make a decision based on the merits of this application in the current position. And I think the report goes into sufficient detail to weigh up, or to first to draw your attention to the consideration, secondly to weigh them up, and third to come to recommendations based on those, having weighed up those considerations. And obviously you've heard what the applicant through their agent has said tonight. Certain factors, but obviously you've got to take this as a whole. And as he rightly pointed out, it's a cumulative impact decision rather than one, if you like, trump card, which would tip it one way or another. So it's a matter for members to consider whether they agree with the weight that's been attached to each consideration in the report, and if for any reason they differ, to say why, say how they differ and why they differ.
Thank you very much. Mr. Brown, is there anything else you would wish to draw to the board's attention?
No, Mr. Chairman, as I say, it's a finely balanced case, as members have said, and I'll just reiterate what Mr. Tobin has said. If you're going to afford different weights to the various elements, then they have to be made explicit in order that the appellant can understand why your decision may be different to the recommendation.
Thank you, Mr. Brown. And I take it from what members are saying, they are generally attaching more weight than you were to the need to protect them. They've recognised the other issues, but the weight that the members who have proposed refusal have explained. Councillor Parsons took a different view and agreed with the weights that you were touching. Could I just check, is there a seconder for Councillor Parsons' proposal? Okay, thank you very much. So we have two proposals. If you don't mind, I will take Councillor Parsons first because that was the one I heard first. So Councillor Parsons, you are, as I understand it, proposing refusal on the basis that's printed in the papers. Councillor Dervick mentioned a change.
I'm proposing acceptance. My apologies. I think I got.
I'm getting ahead of myself.
Absolutely. Yes.
Clearly, you're proposing that consent is granted on the basis printed in the programme.
Yes. Thank you, Chair.
What I was then trying to say is, I think Councillor Dervick alluded to a potential change. Do you want to take that on board, or are you happy with what's printed in the programme? As I understand it, and I'm sure Councillor Dervick will tell me if I'm wrong, it was along the lines of a personal consent as well as a temporary consent.
Yes, actually, just reminded me what Councillor Dervick said, and I absolutely agree with him. Yes,
I couldn't remember what you said.
Well,
I got it wrong.
It was all of 2 minutes ago, you know. Yes, thank you.
So the proposal from Councillor Parsons is that consent be granted as printed and spoken with the addition of a personal consent in addition to what's there. Can I see those in favour of granting consent? Seven. Those against? Nine. So that fails. We now move on to Councillor Riley's proposal, supported by, I think, Councillor Hayfield, which was that planning consent to be refused for the reasons given in the report. And in the fullness of time, if you could write those down so that we're clear for the minutes as to what they were. Can I see those in favour of refusing consent? And those against? Thank you very much. That is carried and planning consent is refused. Members, we now move to application number 261 and 260 for 92 Coleshill Road, Hartshill. Right, anything to add to your report?
Let me just go through the plans, Mr. Chairman, because they're larger versions of what you have in the paper.
Oh, you do, Mr. Banks. Sorry, I should have said, members of the public, if any of you were here for that application and wish to leave, you're perfectly welcome to do so. Equally, we'd be delighted if you wanted to stay for the rest of the meeting. Your call, but Mr. Brown's going to start. Mr. Brown.
Thank you, Mr. Chairman. The first plan shows you the red line there, where the former shop, which is basis Coleshill Road, and the frontage development along the road with the School Hill junction not too far away, which is referred to in the report. This was the plan which was approved for the replacement shop. As you can see, the elevations are there at the top and down the right-hand side, and the layout is bottom left. The current application you have in for variation shows you the 4 elevations, and particularly the fenestration, which is caused, I think, the major issue as far as some of the objectives are concerned. Internally, you can see there the changes. The retail area now takes up about just over half of the ground floor, and the first floor will be storage and ancillary office. And then in terms of the access arrangements, you can see there the shop as was approved with the access arrangements and parking down the side. And as now proposed, you can see this extra space between the parking spaces here and the revised access arrangements. And this is the proposed variation of the car park at the back, as you can see with the markings laid out, the landscaping and other bits and pieces which are included in the report. So, Mr. Chairman, this application, the 2 applications are for variations. The remit of the board, therefore, is limited to those variations. But it's not open to the board to rerun the debate about the actual principle of having a new shop or the new car park. The key consideration here, as the report outlines, is the County Council's view. Now, these applications, bearing in mind these applications have been on over 18 months. The county has objected, but has not come up with any evidence at all to substantiate that objection. And it is also covering highway matters which are not your concern. And that's outlined in the report. Now, I appreciate, Mr. Chairman, this is unusual in the sense that I'm not recommending refusal based on a county objection. However, it is important to recognise that council's response is not a direction. You have to give weight to the county council's direction, and it's a question of what weight you give to it. In most circumstances, we will give substantial weight to what the county is saying. But here there are a number of issues which are outlined in the report, which I don't think means that the county's objection carries substantial weight. And therefore, you have to take a proportionate response, particularly in regard to the local plan policy, which relates to access, and to the NPPF, which also has a paragraph on access and potential refusals on access grounds, which is included in full in the report, and those are referenced in the report. So therefore, Mr. Chairman, I accept this is unusual, but in the circumstances of this case, and given those circumstances, we are recommending that variations be approved.
Thank you, Mr. Brown. Mr. Tobin, anything you'd like to draw to the board's attention from the legal perspective, particularly as regards the county council's objection?
Chair, usually, of course, as the highway authority, their objections, representations will carry significant weight, but they have to be based on evidence, and we have to evaluate that evidence together with everything else that's been submitted in relation to that application. And so it is a weight issue for yourselves. And so you would need to, if you choose to go against the recommendation, have to explain the weight that you attach to any particular reason for refusal and explain.
Thank you, Mr. Tobin. I was fascinated when you were saying that it was a weight issue for myself. There you are. Members, who would like to start the discussion? Councillor Bell.
Thank you, Chairman. Yeah, this shop has been open and running now for some time. It's very popular. It's very successful, and it brings a lot to the local economy. It's really improved the area. It's been a real boost to the area, and the entrance is working extremely well. There's a very wide display. There's been no issues at all. There's been no accidents, no even sign of any accidents. There's plenty of room for cars to go both ways. This application has been to this board several times for many aspects of it, and I really think it's time we drew a line under it. So I'm more than happy to propose the recommendation of approval for both the shop and the car.
Thank you.
I'm happy to second that, Chair.
Councillor.
I'd just like to echo really what Councillor Bell said. It's a massive for our community. I've got work colleagues travelling from Weddington to go and visit, and so many people are talking about this local business. It really, really has brought something, not only to the area but to Nuneaton as well. So, I mean, the car park to the shop has been that way for years. I can't see any planning reasons to keep going over and over this. So I am happy also to second that motion from Councillor Bell.
Thank you. Members, any other comments? In that case, it's been proposed and seconded for consent. I think consent. Those in favour? And that's unanimous. Thank you very much. Now move on to application 7B, application number 76 for the Arden Livery and Menage Chippers Hill Lane, Belongly. Mrs. Van, you indicated that you'd like to speak. If you could take the speaker's chair while Mr. Brown introduces his report.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. It's just the slides really, because this was referred to your last report. The site visit that was taking place, there's a note of that attached as an appendix. Members that went on the site visit, the site is obviously outlined in red, as you can see here, halfway along Chippers Hill Lane. The existing stables are shown there at the top, and then the conversion, as you'll see there, is there. Members, whilst on the site, they saw the site of the hay store, which is being demolished, which is just to the south. I've got nothing further to add. So.
Thank you, Mr. Brown. Mr. Van, there are two of you. You are both very welcome to the Council House. Mr. Tobin will now explain the rules on public engagement.
Good evening. As for the previous speaker, you'll have 3 minutes to address the board, so I'll let you know when your 3 minutes starts. When you've got 1 minute remaining, and then when your time's up, so you put the microphone on. So, your time starts now.
Hello, if I may introduce myself, I am Joy Langley, Clerk and Responsible Finance Officer for Arley Parish Council and Vice Chair of Warwickshire Horse Watch. And my husband is Martin Langley, Chair of Arley Parish Council. I was a serving police officer who retired from CID, based at Addiston in 2003. Martin was born in 1954 at number 50 Gun Hill, New Arley, and had many relatives and close friends living in the Arley parish. We started renting Arden Stables, which was once the old lorry wash, from Justin Potter 19 years ago, and we were able to purchase the stables in 2008. We currently live at 27 Dickens Close, Gallycommon, a home for the past 9 years, but it's never felt like our forever home. This has been valued to Stan and we're planning the conversion. We commute daily to Arden Stables, an active yard, and our daily activities include looking after our horses, the maintenance of fences, the menage, water troughs, grounds and paddocks, etc. And it's also home to many projects, either with the parish council, where we can accept deliveries of building materials, benches and waste bins, or Horse Watch, where our horses are ambassadors. Maisie is on the front cover of Operation Snap, and she recently helped 25 police officers at Merivale Hall on a police training day, showing them on how to deal with coming across loose horses or horses that have been dumped. This training day was to learn on how to approach a horse, to make friends, and how to put on a head collar. It's received great feedback, and we are working on more projects for training, starting with the police cadets. We are looking to make Arden Stables our forever home, as we have no intention of selling or renting it out. It will also provide a respite place for my mum, who after a stroke is losing her short-term memory and has the onset of dementia. At the moment, they still want their independence, but she will still be staying with us from time to time to help Dad out, and eventually they will be moving in with us and will not be going into a care home. Rural crime is high, with stables being broken into and horse trailers being stolen nationally. Being on site would also mean high security and less trouble for both of us. Sometimes I can make 3 or 4 car journeys in the day or at night checking the horses, especially if something doesn't seem right, or when looking by the yard camera, if the security lights have stayed on or not come on at all. Wires have been cut in the past, and we have had problems with theft and damage at the yard. Living on site in bad weather would also mean not having to worry about snow or having the roads being blocked by floods, making it difficult to impossible to get to our horses. We also intend to recycle material and wood, and we're having the process of having owl and bird boxes made and placed in our trees in order to safeguard as much as possible these protected species. Taking down our hay and feed store that's on Greenbelt will improve the openness of the site and will not be encroaching onto our existing land. Well, I hope I have tried to explain how passionate we are on making Arden Stables a home and a place that Martin and I can grow up gracefully, racing down the corridors on our Zimmer frames. Thank you for your time.
Thank you very much. Sorry, do you have any questions for our speakers? In that case, thank you very much indeed.
Thank you.
Members who'd like to start the discussion. Councillor Humphrey.
Yeah, I'm happy to support this. I know we do passionately care about the Greenbelt, but you know, this has been a brownfield site for over 40 years. It's and as you've just heard, that they've rented the site for 20 years. It is an active stable. It is well used. There are buildings already there, so we're not going to harm the Greenbelt. All they're going to do is modify the building. And I know sometimes we need to protect, but if it had been a bovine issue instead of an equine issue, we could have just used Section Q and modified it. And I fully understand that. But I'll support this because this is a family with roots in this area for the whole of their lives. And listening to what Mrs. Langley's just said, for the rest of their lives. So I personally will support it and support the motion. Thank you.
Thank you. Councillor Wyatt.
Thank you, Chair. I'm afraid I cannot support this application for the very same reasons as I didn't support the first one. This goes against policy LP3. It goes against policy LP10, which is about the openness of the Greenbelt, character of the Greenbelt. I went on the site visit and I was taken by fantastic views from this site. And it was indeed classic North Warwickshire rural equestrian landscape. I also thought how different the site would look at night, with domestic lighting, with noise, and with other activity that comes through residential occupation. Without doubt, this is a fantastic location. However, I don't think anywhere in the papers, I don't think on the site visit, nor do I think at any point in tonight's meeting there's any case being made out around significant harm will be caused, lessening that significant harm. So, Chair, I hear the social side of this and the personal side of this application, but this application remains in the Greenbelt, and I do not think the case has been made out to prevent significant harm.
Thank you. Councillor.
Thank you, Chair. I'll second Councillor Humphrey's proposal for support. We're not talking about new structures we're about replacement of existing structures in the Greenbelt, and I think that puts a different complexion on it to me. and despite I get my what's it's in a twist a lot of times over Greenbelt, but not on this one. I think there is sufficient grounds here to be able to support this, and I'll happily second it.
Councillor Riddle.
Thank you, Chair. Again, I went on the site visit. I don't think I've missed one so far. But it is a brick built building. It's an L-shaped brick built building. And obviously speaking to the applicant through Mr. Brown on site, there's not going to be any extensions, and they are taking out ancillary buildings next to it. So it will make it more open. I have to say, Greenbelt is very precious to me, so is our green spaces, but the building is already there. It is already there, and come a government white paper very soon, if the applicant was to apply again, all equestrian buildings will be subject to planning process. I was struck with the fact that that it is open, and it is already there, and I just think that I will support the application because it's already there, and I don't think it will make any difference to the openness of our green site.
Thank you. Mr. Dudley.
No, I've heard all that's said. I went on the visit as well. Part of me agrees with some of those arguments, but I'm actually in agreement with Councillor Riley that I'm not convinced that these are the very special circumstances that would warrant waiving the green belt. It is a stables, it should remain as that, I think. I would second Councillor Riley's proposal.
Can I clarify, Councillor Riley, that you were proposing refusal?
I was, Chair.
Thank you very much. Councillor Bell.
Thank you, Chairman. Yes, I agree with Councillor Ridley. I am usually fighting to the green belt. This is a different case, and according to the papers, it is not inappropriate development in the green belt. It's the existing construction is permanent and substantial, and this one is, and there is no question of it being extended or rebuilt. It's just going to be converted into accommodation, which means that there'll be no change in the outlook. There'll be no change in the openness of the green belt. So it isn't inappropriate development in this particular case, very special circumstances actually, and it's quite unusual to have an application for a conversion where there's going to be no change to the building apart from the inside. So I'm quite happy to propose approval, or second, somebody else is also approved. I'll go along with, because I think it's been seconded too, with the proposal to approve.
You can third it.
I'll third it, thank you.
Councillor Parsons.
Yes, thank you, Chair. I absolutely appreciate Councillor Riley's consistency on this, but I have to be consistent with my position earlier, and so for that very reason, I will be supporting this. Thank you.
Thank you. Mr. Tobin, sorry to call upon you again, but I am slightly uneasy here because we have members on both sides of the argument over whether this is appropriate or inappropriate, and as ever there is weight to be attached. But could you give us some guidance as to appropriateness or otherwise?
I think in the original
Paragraph 9.1, I think.
Sets out that the ordinarily there's a presumption of refusal, which is set out in the National Plan framework, and the appropriate development in the green belt. But it says it distinguishes here that this is a proposal for material change of use of land and reuse of a building. So paragraph 150 D and E say that such proposals are not inappropriate by those conditions, which is then set out further. So that's the issues which have been highlighted by Councillor Bell as well. That the starting point from this is not its inappropriate development.
So do I take it, then your guidance is that if there is a substantial building in the Greenbelt that someone wishes to convert into a house, that is appropriate.
Only on the basis of the facts of this matter, if those conditions in plan in paragraph 150 are met, which is the content of this report.
Thank you. Members, any other comments? Mr. Brown, anything you wish to add?
No, Mr. Chairman.
Just one question for you, Mr. Brown. In the middle of paragraph 9.1, you refer to the amount of traffic that may or may not use the site. I'm just not sure I understand how you imply there may be less traffic.
The existing uses are stables, and there's not just one stable, there are several stables there, there's a menage. You have heard this evening the amount of coming and goings that the applicant makes to this site for all kinds of reasons. In my view, all that activity and the time that is spent on the site by the applicant would be at least equivalent to a normal residential use of this particular site. We're not greater in the circumstances of this site to the comings and goings and activity at the site.
Thank you. Members, we've had two proposals, one that consent is granted, one refused. In line with what I did earlier on, I heard the proposal from Councillor Humphreys that consent be granted first. So if you don't mind, we'll take that one first. Can I see all those in favour of granting consent as printed in the programme? I believe, Councillor Humphreys?
Yes.
All those in favour? There's a slim majority there. And those against? So, members, that is carried. Planning permission is granted, and I think, I'm sorry, Councillor Rye, we don't need to go to your recommendation because.
Thank you.
Members, we now move to application number 473 for the Paddocks Church Lane, Crawley. Mr. Brown, anything to add to your report?
That's right, Mr. Chairman, just to repeat, record the plan that was already attached, so you can see a bit more detail. The history of the site and why we are reporting it tonight is explained in the report.
Members, any comments or questions? Mr. Brown, I have some around the issue rather than on the issue. It is quite concerning. We've got to this point where 4 years after the event, that or more, that we are in this position. Are there any other applications or consents that have not been followed through in this way?
No, Mr. Chairman, this is unusual because it's relating to a Section 106 agreement. Normally, there are matters like this related to planning issues and technical reasons, which have to be overcome before we can make a decision or bring them to board. This is a Section 106 issue, which is a legal issue, which is not the same.
And I take it, Mr. Brown, that the applicant could now show lawful use. As given the amount of time that has passed, is that correct?
This is mentioned in the report, Mr. Chairman, the final sentence of observations. I say members should be aware that the building will be lawful due to the lapse of time in March next year.
Sorry, Mr. Brown, I've missed that. Thank you. Members, any comments or questions or proposals? Councillor Riley.
Chair, I am alarmed to see that the 106 was not entered into by the applicant. Is there anything that Mr. Tobin and Mr. Brown could advise that could help us make sure that there is some protection on this building? Because one of the things that we know, indeed, the application before us regularly sees buildings get approval for one purpose and then have it changed for another purpose later on. I am, as I say, concerned that the applicant has chosen not to sign the 106, which I don't know whether I can draw an inference from by the decision not to sign the 106, but it causes me concern.
So, Mr. Tobin, if you could answer Councillor Riley's question. My concern is similar to that, is if the board reaches a decision subject to something, then the applicant simply chooses not to do it. What's the point?
Chair, in this instance, as the report points out, it is the use which would have been secured by the Section 106 agreement is the use which is continuing. So there isn't, in that respect, a detriment in that they've not departed from that use. I understand members' frustration that that's not being progressed. However, as with all applications, it's a matter of considering in light of the current position. And the current position is that that use will become lawful, but is not a departure from what the board sought to grant in the first place.
And I understand your answer, Mr. Token, but at the time, by going for a 106 agreement, the board was seeking to have a defensible position that lasted not just for 4 years, but that lasted full stop. The 106 agreement, we are always told, is a stronger position for the board to have than a condition. That was why the board chose to have a 106 agreement. There was a reason for it. It wasn't simply felt like it on the day. That is no longer the case. Except from what you're saying, that clearly the use of the building is what the board would have wished. But the position I think the board was trying to reach was a longer term defensible position. That is no longer the case. What I'm looking for is some confirmation, some assurance that if the board chooses to grant consent in the future subject to a 106 agreement, that it's actually delivered. Councillor Riley.
Yeah, I mean, I'll seek the guidance of officers, but I am troubled by this decision of the applicant not to sign the 106 and yet to go ahead to build the structure and to make use of the structure. In many ways, it raises a question about the value of the decisions of this board going forward. Is there a scope where we could perhaps consider deferring this application and then having the applicant discuss with officers whether they will now sign a 106, and that decision being brought back to this board to inform our decision making?
Call me flippant, if you will, but we reached the decision 4 years ago. It hasn't been enacted now. We'll have have lawful use in March next year. I don't think it matters if the board makes the decision tonight or the next meeting, frankly. So I would say yes, it's perfectly reasonable to go for a deferral, unless you have a reason why we should not.
No, there is still time between now and next month, so it's not as if this is the last opportunity.
Thank you.
In which case, Chair, I would propose a deferment to the next meeting with a request that officers speak to the applicant, understand why they do not wish to sign a 106, and then have that matter reported back to the board. And if you wouldn't mind, I'd couple that with what can the board do if this set of circumstances occurs again? Yes, totally, Chair.
Members, any other comments or any alternative recommendations?
I think we should put the time there is still plenty of time for us to take this action if we still get no signature on no such agreement.
I think we've got too much, but yes, I agree with you.
I think it should be before then, because
I would expect this to come back to the next meeting. Members, any other comments? Councillor Riley has proposed deferment. Is there a seconder? Councillor Bates, any other proposal? In which case, you haven't received those in favour of deferment. That's unanimous. Thank you very much. The next application is number 40 for Trajan Hill, Spinney Trajan Hill Coleshill. Mr. Chris Timmins has indicated he'd like to speak. Mr. Timmins, you can take the speaker's chair while Mr. Brown introduces his report. Mr. Brown.
Right, thank you, Mr. Chairman. Just going through the slides. Members should be familiar with the site of Trajan Hill, which is the coal site at the top there, 446. On the left-hand side, and the buildings down here, the residential estates surrounding it, with the former workings in here. Members, I think, are familiar with the plan to develop the 20 odd houses off Trajan Hill. And the issue that we have, Mr. Chairman, is outlined in the report. The outline permission dealt with issues such as access, temporary access, construction access off the 446. That is being looked at technically by the Highway Authority, by the applicant, and it just would not be workable or practicable. And therefore the decision has been taken to come off Trajan Hill, which itself creates its own particular planning issues in terms of the adequacy of Trajan Hill and the construction traffic that has to come in and out of it. An awful lot of work has been done between the applicant, the residents, and the Highway Authority in order to agree a construction management plan. And one of the key issues, I think, which members keep repeating on several times when they deal with applications like this and others, and indeed others, is that there has to be communication between the developer and the residents on a regular basis to explain what is going on, when it's going to go on, and if problems do arise, how they're going to be resolved. In view of that engagement, Mr. Chairman, and the plans that have been submitted, we're comfortable with recommending approval of the discharge condition.
Thank you, Mr. Brown. Mr. Summers, welcome to the council. Mr. Tobin will explain the rules on public engagement, which you might have heard before, but we'll let you know again. Mr. Tobin.
Good evening. As you heard from your applicants, you'll get 3 minutes to address the board, so I'll let you know when the time's when you've got a minute remaining, and then 3 minutes is ended. So I don't know if you press the happen. Your time starts now.
Thank you. Good evening all. My name is Mr. Timmins. I'm the Managing Director for Exeter Partnerships, and we are very much a regional SME developer. The scheme will be an affordable housing scheme. We are SME who deliver all our schemes as affordable housing, which is backed by Homes England and central government. The development concerned will be going through a registered provider called Citizen Housing, and we've already got Homes England assigned to the project. We truly want to deliver the scheme in the highest quality and to the minimum disruption to the local residents. And I think that some of the members will support us in my statement to say that we're truly engaged with the planning team, the planning board, local residents, make sure that our planning strategy, our access and egress strategy is safe. And probably, apologies, and safe and probably reasonable for residents. The condition discharge revisits the levels, the access and the drainage to the development, which will probably allow us to be more streamlined, efficient, and I would say an environmental conscious development, because we are going to be utilising timber frame for construction. It will allow us to connect our storm drainage not into the A446, and also allow us not to access the site by construction traffic off the A446, which you all agree cause quite a lot of disruption to the local area. Our cut and fill design has been optimised to ensure that we do not generate any excess arising from the site, which will allow what we call the cartway or the multi-factor exercise to be minimal, which will also allow a minimal disruption to the local residents. The project will be registered for a considered constructor scheme. We will have a dedicated health and safety manager, construction manager for the scheme. We'll have a dedicated site manager and a site team to the project, and we'll have a banksman on the front of the development at all times, allowing also a wheel wash when the need requires and road sweepers when there's excess groundworks to be done. We'll be doing deliveries not before 9 o'clock and definitely not between 3 and 4 o'clock of the day. Thank you.
Thank you very much. Members, do you have any questions for our speaker? Councillor Riley.
Thank you. Two things. First of all, the construction label plan. And then secondly, as you'll see in the board papers, it references landfill and importation of landfill operations and importation of waste and material. So I'm pleased that you remembered significant public opposition was against this proposal originally, and I'm certainly pleased that any suggestion now about access to the site from the A446 has been withdrawn, because the world, as you know, in North Warwickshire has changed with the construction of HS2, and we know that the 446 at this point is a construction route which will, over the next 4 years, involve the transportation by road along the A446, so possibly somewhere in the region of 2.8 million tonnes of spoil. So anything that avoids congesting the A446 in any way is good. Now, part of the challenge, as you recognise, is how do you get your construction materials in with the least inconvenience to residents? I'm pleased to hear that you're going to do some positive community engagement and that you will be doing regular engagement during the build. Can I ask that you also include the two local members in that engagement process? And they are Councillor Peter Fowler, who has got an interest in this application, but also Councillor Jane Farrow, who is the other Coleswell. Both members received a significant challenge last time the application came forward, and it would be good to make sure that we did manage any concerns effectively that came forward about the impact on moving to construction material to the site, because knowing it is an absolute challenge.
It is a challenge, but I'm confident with the team, us as a business, that we will manage that challenge. I think we've had lots of engagement to date to try and get through the degree of traffic management plan. I also think that early engagement with yourselves and the local residents on not only our strategies, but also contact numbers, what we're going to do, not just to mitigate the upshift, but also for our contractors parking and for all the deliveries in terms of roof trusses and timber frame. We'd want to really give people comfort on our strategy, rather than me just telling you this is the strategy. I want the residents to feel really good in what we're going to do, and I believe we can do.
Thank you. My second point then is about landfills. So like every resident of Coleswell of a certain age, we know the site well from trespassers' kids, and I know it's a really great hole. Now, with the original application, I was concerned about any importation of waste or other material onto this site. Can you just assure me that you will not be importing anything to do with landfill onto this site?
Absolutely, we will not be doing that. The strategy, because what we do, the levels change. We are trying to use the existing horizons from the site in terms of from drainage and foundations, which will remain on site. The only material what will be brought onto site will be clean topsoil as part of the building recondition.
Thank you.
Members, any other questions? Councillor Ryan. Sorry, Councillor Humphreys.
And ask another question. One of the main issues that I always get as a local council when there's local development is the breaking into the site. You can't make a cake without breaking eggs, as you know. And the problem is you have to break into the site. This is a very, very difficult site, and you're talking about labour. Where's the labour to go? And when you drop the machine, there's going to be diggers, all sorts of stuff there. How do you keep? Are you going to come in from Trajan Hill, or are you intended to break in from the 444? But then the point I'm making, things have to arrive and be working on before you manage to do a proper break-in, and where people go.
They were, and we've spoken to our ground workers on that. So we're coming through Trojan Hill, through one of the properties that will be formed the access. That property is a 2-storey dwelling, so the amount of demolition you would need for that is minimal compared to what you'd look on a big commercial development. So we'd be very sensitive in terms of the machinery that we would use for that demolition. But the good thing about that, once that's been demolished, you've then got to stand up between the back of the footpath and between the back of the garden to allow all the machinery and any small accommodation to be on the footprint of the dwelling rather than being on the roads. So therefore, then when you break in, you're free from any sort of pedestrians or any roads. So we're confident we can manage that because of the dwelling that we're demolishing.
Thanks very much. That's a plan then.
Certainly. Thank you.
Just a technical question, if you don't mind. Have you undertaken any work on site to commence the planning application that you were granted in 2016?
We've undertaken surveys and ground investigation works to allow us for the intelligence in terms of our foundation and drainage structure. So we've undertaken work, yes.
Thank you. Members, any other questions? In which case, thank you very much indeed.
Thank you.
Mr. Brown, I'd just like to follow on from that because I am slightly confused. So we have a discharge of application, a discharge conditions 9, 10 and 11. And from that I presume that that's all we're doing. We're changing 9, 10, 11. The consent granted in 2016 still applies. But if not, my technical questions, because I'm being anal about it, is surely we had a standard 3-year condition back in 2016. And given what the applicants have just said, have they taken up that consent or not?
When you're granting outline permission, which it was in the first place, the outline requires you to submit your reserved matters within 3 years. And from the approval of the reserved matters, it's 2 years after that approval that they need to commence works. I'm just looking for the date because I think it's next year that they need to implement the permission by, which is 2 years after that reserved matters. Just bear with me.
Okay, no, I'm generally happy at what you said, but I think perhaps the board could have some training on how that works, because I know we've had other applications which have gone outside of that 3-year period, on which may appear later on the agenda, and I'd just like to understand how that works, because it's appearing confused.
Your outline can be 5 years, the way it works, the wording of the standard conditions from government, whereas a full application is restricted to those 3 years. But the outline can require, can lead to, and it has in this instance, because the reserved matters was submitted on the last day of the 3rd year, and it took almost 2 years to approve it, the reserve matter scheme.
Okay, and can I just, for absolute clarity, there's nothing on any of the other conditions that requires a change?
All the other changes have been carried out, and the subsequent discharge of conditions are likely to be submitted very shortly. But I think what the applicant has tried to do is concentrate on the most difficult ones at the moment, which is knowing the proximity of residential properties. They've concentrated on construction management and tried to allay fears of that.
I'm content, honestly, Mr. Carson, with that, and I'm not seeking to, if you like, first spanner in the works. I just want to be sure that when the board votes on it, that we have, if you like, discharged the conditions, or are there more that will need to come back to us?
There are some more. It's whether they need to come back to board or not. I think certainly this is probably the most important, bearing in mind it has impact on residential properties.
Okay, thank you. Members, any comments, questions, proposals? Councillor Hayfield.
This was a difficult application when it first came to us. I am reassured by the approach they're now taking, and I'll move that we give approval the discharge of the conditions as listed in the paper.
Thank you. Any by Councillor Ryan?
Seconded.
Any other comments, members? In which case, can I see those in favour of discharging conditions 9, 10 and 11? Thank you, that's unanimous. Members, we now move on to my agenda. Agenda item number 8, which is the budgetary control report for 22-23. for the period ending 31st of August. Mr. Brown, would you like to explain the budgetary control report?
Well, I think the Assistant Director of Finance has done that for you, Mr. Chair, and I'm happy to take any questions should they arise.
Neatly done, Mr. Brown.
Do we draw any parallels, Mr. Brown, with the Heritage and Conservation Officers being on holiday and the fact that we've underspent by £21?
I shall report that back to her, Mr. Chairman, and look at where she's going next year round.
Members, I would just like, in the spirit of be thorough with this, it is unusual for us to be £57,000 adrift at this point in the financial year, and it is concerning. Whether or not we're at the stage where we need to flag that up to the executive and ask for a supplementary estimate, I'm not sure. But I don't think any of us are comfortable with the fact that we are so adrift on that. But Mr. Brown, would you like to give the board assurance that you'll be burning the midnight oil to follow Ms. Ledbetter's lead?
In respect of these, Mr. Chairman, members will be aware that the application for WH Smith and Walter Orton has now come in. That fee, which is £30,000, has not been included in this because of the time period. Members are also aware that a number of pre-application meetings are being held with speculative applications, which are likely to come in round about the beginning of the new year, and those will be quite substantial figures. We are also expecting, and there are being pre-application meetings to look at the allocated sites in the local plan, particularly the one that's moving forward quite quickly is H1, H2 at Atherstone. There's one landowner, one applicant involved there, and I'm expecting that application probably to come in, or the outline application for that to come in before the end of the financial year. So there is hope, Mr. Chairman.
I hope indeed, Mr. Brown. If you can cut the deficit in half in one meeting, then I think you should go and work for central government. Members, any comments or anything else you want to say, or are we happy to note Mr. Brown's report? I'll propose that we note it. Seconded. All those in favour? Thank you. That's unanimous. Agenda item number 9 is a tree preservation order for land at Wellspring Clump Carlian Industrial Estate, Atherstone. Mr. Brown.
Nothing further, Mr. Chairman. This is to confirm the order which has already been made. The report outlines one or two matters which do need to be considered by the board, or sometimes do arise when you're confirming TPOs. The first is that there is an outstanding planning application here on the same land. Confirming the order does not prejudice the outcome of that outstanding planning application. The order, if confirmed, will become a material consideration when you consider that planning application, and it'll have to be put into the final balance, as we've been talking about on other items. The other item is for the representation that's been received. There are a couple of technical issues there, which I think we've responded to in the report. And also, the report indicates that there have been some of the trees are dead. Confirmation of a TPO does not mean that the dead tree is preserved. There are clauses in the regulations to enable dead trees to be removed without seeking our consent. We would want evidence of that, but it is quite usual.
Thank you. Councillor Jarvis.
Thank you, Chair. Knowing this area quite well and using it very frequently, this footpath is it runs from Race Meadow, from Ratcliffe Road through to the QE school. Between myself and Councillor Singh, we have got the County Council to open this footpath up, because the trees from both sides were touching in the middle, and it was very difficult to walk up there, let alone get up there in any other way. Looking at the report, I mean, this area is very much overgrown, very much with antisocial behaviour, that the police have been down there with drug taking, there's been burnt out motorcycles down there. numerous incidents down there. Looking at the bottom of one paragraph of page 61 of 120, it says the overall land appears to sit adjacent to an unmade footpath that follows the A5 from Wellspring Close to Ratcliffe Road in a northwesterly direction. This is not a public right-of-way. I've used that footpath now for in excess of 60 years because it was the shortcut when we did cross-country at school that we used to nip down there to cut out going through Radcliffe. That apart, that to say that it's not a public right-of-way and it's an unmade path are both inaccuracies. Between that and the A5, there's a strip of mature trees. Yes, ain't got a problem. But the mature trees and vegetation, it's a mess. I don't think there's any concern in putting TPOs on the trees that merit it. Again, no real concern of that. But with the inaccuracies on this, I would like to propose that we defer this until these inaccuracies are actually addressed and the report gives factual rather than inaccurate details. Thank you.
Thank you, Councillor Barnett. Did I see you? Okay, no, sorry. Councillor Derby.
Thank you. I think it's very clear from the map where this is situated, and I think this is an area of woodland that does have good value. Take on board what Councillor Jarvis has said about antisocial behaviour and the state of some of the area there. But this is an area of woodland that is very visible from quite a large area. I think it adds a lot to breaking up the edge of the industrial estate from town side, and it improves the outlook from within the industrial estate as well, Carleon Road. I think that notwithstanding what Councillor Jarvis has said, we should confirm this TPO.
Thank you.
I would propose that we do that, that we confirm the order.
Councillor Ryan?
Can I ask for a point of clarification from Councillor Durfix, please? Did he cheat at cross country as well?
No, I was trying to catch them out at it.
Because he was
I taught there. But not when he was there.
I'm not sure it's entirely relevant to the conversation, but there's a bit of openness to get the bus back on the classroom view.
I think the key thing through you, Chair, is that the inaccuracies in there stating that it's unmade, and it is, and stating that it's not a public right of way, and it is.
So, Mr. Toby, could you give us some guidance?
Well, that's the representation that's being made by the adjacent landowner who's got the planning application in, and you take that account of that with all the other information you have. So that's a representation. It's not definitive. It doesn't mean that is the case. But ultimately, whether or not there's a public right of way or not, it doesn't alter the issue of whether the trees justify preservation. I fully understand the point that's being made, because it doesn't seem to be accurate, because the county council have obviously responded to requests to maintain that public footpath. My understanding is it's shown on the definitive map. So it's a matter of how much weight you attach to that representation, and if you have information before you that shows that representation contains incorrect information, then of course that to me it carries very little weight. But ultimately, whatever case may be. As I said, it's about whether those trees themselves justify protection.
So if I could push you just a little bit further, the recommendation is that the board confirms the order. Is there a risk to the trees if, I mean, at the minute there is a temporary order on them? Is there a risk in the board taking a bit longer to correct some of the issues? How long is the temporary order in force until it's confirmed?
Mr. Brown has just had his hand up.
Oh, Mr. Brown.
Firstly, just correct Councillor Jarvis. I agree with Mr. Tobin. The representation, or the quote you're taking is from the representations letter, is not the officer's view. It's the representation that you can see. Secondly, the order the temporary order lapses in the next week, which is why it's being brought to you tonight.
Thank you very much. So I don't know who I saw first. Councillor Parsons.
Thank you, Chair. I mean, yes, if there are inaccuracies, perhaps they need sorting out, but they don't seem to be relevant to the issue that we're dealing with, which is the tree preservation orders. And I would like to second Councillor Dervick's proposal and get on pass that over.
Having got a tree preservation order which took 2 years, I think public right-of-way accessibility and how obvious the tree is and how important it is to the community is a massive thing. So perhaps if somebody was saying that there's not a public right-of-way, it wasn't, that could have been something to do with it's not really suitable to be designated as under a tree preservation order. So I do think it does have a material bearing on how important that tree is to the community. It's a visual asset.
Can I just reinstate that it isn't the immediate vicinity of these trees either. They can be seen right the way across Ammerston from a long way. So it's not just from that footpath.
So, Mr. Tobin, give us some guidance here. So what I think I've heard is we can confirm the order tonight. If we don't, it lapses and we have to go through the process again. If we confirmed it tonight, could we vary it to correct it within a short amount of time, or are we then, is this what it is and it stays as it is? I'm a bit confused as to what the board's potential movement could be.
Well, first is the order, the order, if not confirmed within 6 months, will lapse. So that will be the end of this week. I think it's like the weekend. So that means that there would be risk to the trees if you don't confirm. There's no option to, if you adjourn this matter now, then the protection ends. The second point is that the merits of the original order being made are based on the tree assessment report, which is pages 56 of 120 and the tree inventory report that follows on. And those, the comments in that report are not contingent on whether there's a footpath next to it. The trees can be seen from a distance, they form part of that landscape, but there is detail in that report as to why they merit, using that evaluation method, why they merit protection. So unless members can see anything that's changed from when the original decision was made to make the tree preservation order, it would normally follow that you confirm. You've got a representation that refers to several matters. The bit of a red herring. Is there anything that representation says that, in members' view, changes anything about that original order in relation to the trees themselves? That's the only possible change to the previous decision. If you now have some information you didn't have then, or the information you have now changes the weight of whether they merit protection. So it's that report set out, and it gives the scoring process, which clearly comes down in favour of protection.
Thank you. Councillor Waffle.
Yeah, I was just going to say, can we not make a slight amendment to the proposal, which takes on board the considerations of the two local councillors that know the area very well, to amend the inaccuracies as part of the proposal for the motion, and then consider the motion with those inaccuracies being reworded?
Which inaccuracies?
But they're not inaccuracies.
They're views of an individual. The order itself has been made. Now, it could be varied to protect different trees if there was merit to doing that, to exclude certain trees that were within it. But in terms of inaccuracies, which of the inaccuracies you believe were in the order itself?
Well, as I'm not one of the local councillors, I was going to say, if the local councillors believe there was inaccuracies in the wording, that was all. It was more about the wording rather than the actual protection of the trees themselves.
Not of the order.
Not of the order, but as in of the report, you know. So I was thinking if you could reword that slightly to make everyone happy, and then the TPO would be.
The report has to bring back to you representations that have been made. That's what has to be considered. It's the council's duty to consider at this stage any representations being made. It has to be taken on its merits. It has to consider the impact that representation has on the trees and whether they need protected. So that's what should be taken from this representation, and whether or not there's a book doesn't alter the test.
Yeah.
It's got to be met.
So if I understand then, what you're saying is that the order is correct, it refers to the right trees. The inaccuracies are more omitted rather than in the order.
Yeah, they're. I'm sorry, Chair, I just realised I didn't answer your second point, which was about whether it could be varied in a short space of time. A tree preservation order can be varied at any time, but obviously there needs to be a grounds to do so. So as you have it tonight, you have an order that's been made, which will expire next week. You have a representation that raises some matters connected to trees, but others which aren't. If you make the order tonight and other information comes to light regarding the trees at some other time, you'd have to consider that on its merits. But obviously, that's an if.
So we can vary it.
Yeah, as any order could be.
Okay. Councillor Hobby has been waiting extremely patiently, so it's her turn now.
So sorry, just as a point of clarity, regardless of the points made by Councillor Jarvis, the points are not going to change on the reason why the tree needs a TPO. No. So it would be in the benefit for the trees past the TPO as it is. Is that correct?
That's what the thought is.
Yeah.
Is recommended.
Okay. Thank you.
Thank you. Councillor Parsons.
I was just going to say, Chair, it seems to me that actually this order has absolutely no bearing on the right of way, whether there's a right of way there or not. This is an order about tree protections. So, you know, if we pass the order, it doesn't alter anything about the right of way being a right of way or not being a right of way. Therefore, I can't see it's relevant to this.
Any other comments? Councillor Hayfield.
It's a case of not seeing the wood for the trees.
Oh, Councillor Hayfield, it must have taken you at least half an hour.
I understand Councillor Johnson's frustration with the detail of the site that he knows well is clearly not reflected in aspects of the report. But I do take on board the fact that it really isn't relevant to whether we confirm the order or not. And if the existing temporary order is about to expire, then we should jolly well get on and just confirm the order and give whoever wrote that report a smack around the head saying that he didn't get it right.
Councillor Hayfield, that was the report of the head of development control.
Can I just repeat, Mr. Chairman, it is that reference is not in my report. It's in a letter from the representation. The letter.
I didn't say it was.
Okay, members, I think we've had a fairly thorough conversation. I've heard, I think, two proposals. One, that the order is confirmed. One, that the order is that the matter is deferred. I think to all intents and purposes, it's an opposite. So, you know, if you vote to confirm the order, then clearly you're not voting for a deferment. So if the two proposals don't mind, we'll confirm the order first. If that fails, then we will naturally go to deferment. So can I see those in favour of confirming the order? Slim majority again here. Those against confirming the order? I'm afraid you lost that one.
So, yeah.
Jarvis. I hope the next order isn't going to take quite so long. Mr. Brown, agenda item number 10, PPO for land west of Waterlands.
This is a repeat, Mr. Chairman. Different sites, different trees, and the representations that we've received are outlined there, but that would not alter our recommendation to confirm this particular order.
Councillor Riley.
Thank you, Chair. Speaking as the local member, I encourage all members to support the recommendation of approval. If you look at page 1.3 of 120 in the report, what you will see is probably the best photograph illustrating the risk to all of these trees, and that is the Bromford Tull. I spoke earlier about 3.5 million tonnes of spoil coming down the A446. That's the very site it's going to be coming at.
10.1.3.
1.13 of 120.
Sorting chair, I'll second that.
Anyone else? Any other comments? It's been proposed. I'll second the recommendation. All those in favour? Thank you very much. That's carried. Mr. Brown, agenda item number 11 is an appeal update.
It's just a note, Mr. Chairman. I'll answer any questions if there are.
Any questions for Mr. Brown? Could you remind us how many appeals you've won compared to lost so far this year?
That's 4 in a row, Mr. Chairman.
Honestly, members, that was not a planting question.
Chair, well done. You've queued him up. You're going to go away with a smile now.
Members, can I propose that be noted?
Mr. Radcliffe.
Thank you, everyone. The chip shop is still open, although I'm going to coach.